Hi, my name is Derek McKee. I'm a law professor at the Université de Montréal, and in this capsule, I'm going to talk about the role of guidelines in administrative law. As you know, administrative law largely deals with how government officials implement statutes and sometimes regulations as well. But government administration is often guided by informal norms too. These norms have many different names. We can talk about guidelines, policies, directives, operational manuals. Sometimes academics like to use the term soft law as a general description to group all of these together. In general, in this module, I'm going to use the word guidelines, but keep in mind that the exact label is not all that important. Now, what's special about guidelines is that they are not legally binding, but they can still play an important role in public administration and in administrative law. Guidelines are generally seen as a way of promoting consistency in the interpretation of a statute. So imagine a large organization like a government department that administers a complex social program. You might have hundreds of civil servants dealing with individual files and determining how the law should be applied to them. These officials might decide to create guidelines, trying to standardize how they apply the law in certain kinds of cases. The guidelines would then be approved by the minister and would be officially considered as a kind of instruction from the minister to his or her subordinates in the department. They would be seen as a way of helping the minister to delegate his or her authority. So, functionally, guidelines may play a role similar to regulations in that they're a way for the executive to flesh out the details of a statute. However, in terms of their legal status, guidelines are very different from regulations. For one thing, unlike regulations, guidelines are not legally binding. They can't be used to impose legal obligations on ordinary members of the public. That's why we talk about soft law. Guidelines are really meant to guide public officials in their work. So a bureaucrat who ignores a guideline could be in trouble with his or her boss, but he or she would not be breaking the law, strictly speaking. Another difference between guidelines and regulations has to do with the source of authority to create them. For the executive to make regulations, it needs an explicit delegation of regulatory authority in a statute. For guidelines, however, that's not the case. There are some statutes that explicitly grant power to make guidelines. You can find a good example of this in the Immigration and Refugee Protection Act at paragraph 159(1)(h), where you can see that the chairperson of the Immigration and Refugee Board is authorized to issue guidelines to members of that board. But more often, frankly, the power is implicit. Often it's just simply the case that government authorities that are responsible for administering statutes are assumed to have the power to establish internal guidelines as to how those statutes should be interpreted and applied. Now, all of this said in terms of the distinction between guidelines and regulations, it's important to look beyond the labels used to properly distinguish, to properly make the distinction. There's a Supreme Court case from 1992, the Oldman River case, that dealt with a federal guidelines order in relation to environmental assessment. And in that case, the Supreme Court looked at the entire statutory context and held that this so-called guidelines order was in fact a binding regulation, despite the name. Another important point that I want to make is that even if guidelines are not themselves legally binding, they can influence the way courts review administrative action, review administrative decisions. So you remember the Baker case, the case in which Mavis Baker's application to remain in Canada on humanitarian and compassionate grounds had been turned down? Well, that was, of course, a discretionary decision. It was a decision made by immigration officers who were acting in the name of the minister. But there were also ministerial guidelines that applied in that situation. Among other things, these guidelines made it clear that immigration officers were supposed to consider the impact of deportation on family members, such as Mavis Baker's Canadian children. But the Supreme Court highlighted the fact that the immigration officers in charge of Ms. Baker's file ignored this guideline. This was one of the factors that made her decision unreasonable. Justice Le Roux-Dubé, writing for the majority, wrote that the guidelines are a useful indicator of what constitutes a reasonable interpretation of the power conferred by the section. And the fact that this decision was contrary to their directives is of great help in assessing whether the decision was an unreasonable exercise of the humanitarian and compassionate power. The Supreme Court actually reaffirmed this position that guidelines can be relevant in assessing reasonableness in the 2019 Vavilov case. The majority in that case stated that the reviewing court might consider, among other things, publicly available policies or guidelines that informed the decision maker's work. The court also noted approvingly that institutions also routinely rely on standards, policy directives, and internal legal opinions to encourage greater uniformity and guide the work of frontline decision makers. So, on the one hand, administrative decision makers can't ignore guidelines. But on the other hand, administrative decision makers have to be careful not to follow guidelines too closely. There is an example of this problem in another Supreme Court case dealing with humanitarian and compassionate exceptions, the Kantasamy decision from 2015. In that case, the Supreme Court overturned the refusal of a humanitarian and compassionate application because it found that the officer had followed the guidelines too strictly, treating them as if they were a binding rule, and thereby fettering her discretion. This same type of issue, excessive rigidity with respect to the application of guidelines, might also give rise to an issue of procedural unfairness or bias. If you imagine an administrative tribunal where there are multiple tribunal members, each hearing particular cases and deciding them on their merits, if the chair of that tribunal were to issue guidelines that essentially forced tribunal members to decide certain kinds of cases in a certain way, that could conceivably violate the rule, she who hears must decide, which would be contrary to the audi alteram partem principle. Depending on the circumstances, it might also end up being considered a form of institutional bias, which would be contrary to the nemo iudex principle. Now, I've covered some of the legal issues that arise from the use of guidelines, but to end this capsule, I just want to return to an issue that I alluded to at the beginning, which is why is it that government departments and other entities use guidelines? In order to answer this question, one has to consider the alternatives. On one hand, guidelines can be seen as an alternative to open-ended discretion. So from this perspective, guidelines have the advantage of promoting consistency. Remember that statutes are sometimes drafted in broad general language, leaving the details to be filled in later. So it might be preferable to know that different decision makers within an organization are interpreting the statute in roughly the same way, and guidelines can help them to do that. On the other hand, guidelines can be seen as an alternative to regulations or other kinds of hard law. From this perspective, guidelines have the advantage of flexibility. They're easier to change and they don't require any formal process. In a 2007 case called Damodaram, one of Canada's great administrative law judges, John Evans of the Federal Court of Appeal, explained the use of guidelines as follows. He said, "Effective decision-making by administrative agencies often involves striking a balance between general rules and the exercise of ad hoc discretion, or to put it another way, between the benefits of certainty and consistency on the one hand, and of flexibility and fact-specific solutions on the other. Legislative instruments, including such non-legally binding soft law documents as policy statements, guidelines, manuals, and handbooks, can assist members of the public to predict how an agency is likely to exercise its statutory discretion and to arrange their affairs accordingly, and enable an agency to deal with a problem comprehensively and proactively, rather than incrementally and reactively on a case-by-case basis. Through the use of soft law, an agency can communicate prospectively its thinking on an issue to agency members and staff, as well as to the public at large and to the agency's stakeholders in particular. Because soft law instruments may be put in place relatively easily and adjusted in the light of day-to-day experience, they may be preferable to formal rules requiring external approval and possibly drafting appropriate for legislation." So what Justice Evans is saying here is that guidelines may provide a useful middle ground between legislated rules and administrative discretion. If used well, they can combine the advantages of both. However, as we have seen in this capsule, they can also give rise to their own sets of challenges.